United States v. Williams, Supreme Court, 1992. Justice Scalia delivered the opinion of the court. The question presented in this case is whether a district court may dismiss an otherwise valid indictment because the government failed to disclose the grand jury substantial exculpatory evidence in its possession. Respondent does not contend that the Fifth Amendment itself obliges the prosecutor to disclose substantial exculpatory evidence in his possession to the grand jury. Instead, building on our statement that the federal courts may, within limits, formulate procedural rules not specifically required by the Constitution or the Congress, he argues that an imposition of a disclosure rule is supported by the court's supervisory power. We think not. Bank of Nova Scotia v. United States in 1988 makes clear that the supervisory power can be used to dismiss an indictment because of misconduct before the grand jury, at least where that misconduct amounts to a violation of one of those few clear rules which were carefully drafted and approved by this court and by Congress to ensure the integrity of the grand jury's functions. We did not hold in Bank of Nova Scotia, however, that the court's supervisory power could be used not merely as a means of enforcing or vindicating legally compelled standards of prosecutorial conduct before the grand jury, but as a means of prescribing those standards of prosecutorial conduct in the first instance, just as it may be used as a means of establishing standards of prosecutorial conduct before the courts themselves. Rooted in long centuries of Anglo-American history, the grand jury is mentioned in the Bill of Rights, but not in the body of the Constitution. It has not been textually assigned, therefore, to any of the branches described in the first three articles. It is a constitutional fixture in its own right. In fact, the whole theory of its function is that it belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people. Although the grand jury normally operates, of course, in the courthouse and under judicial auspices, its intentional relationship with the judicial branch has traditionally been, so to speak, at arm's length. Judges' direct involvement in the functioning of the grand jury has generally been confined to the constitutive one of calling the grand jurors together and administering their oaths of office. The grand jury's functional independence from the judicial branch is evident both in the scope of its power to investigate criminal wrongdoing and in the manner in which that power is exercised. Unlike a court whose jurisdiction is predicated upon a specific case or controversy, the grand jury can investigate merely on suspicion that the law is being violated or even because it wants assurance that it is not. It need not identify the offender it suspects or even the precise nature of the offense it is investigating. The grand jury requires no authorization from its constituting court to initiate an investigation, nor does the prosecutor require leave of court to seek a grand jury indictment. And in its day-to-day functioning, the grand jury generally operates without the interference of a presiding judge. We have insisted that the grand jury remain free to pursue its investigations unhindered by external influence or supervision, so long as it does not trench upon the legitimate rights of any witness called before it. Recognizing this tradition of independence, we have said that the Fifth Amendment's constitutional guarantee presupposes an investigative body acting independently of either prosecuting attorney or judge. We have twice suggested, though not held, that the Sixth Amendment right to counsel does not attach when an individual is summoned to appear before a grand jury, even if he is the subject of the investigation. And although the grand jury may not force a witness to answer questions in violation of the Fifth Amendment's constitutional guarantee against self-incrimination, our cases suggest that an indictment obtained through the use of evidence previously obtained in violation of the privilege against self-incrimination is nevertheless valid. Given the grand jury's operational separateness from its constituting court, it should come as no surprise that we have been reluctant to invoke the judicial supervisory power as a basis for prescribing modes of grand jury procedure. Respondent makes a generalized appeal to functional notions. Judicial supervision of the quantity and quality of the evidence relied upon by the grand jury plainly facilitates, he says, the grand jury's performance of its twin historical responsibilities, i.e., bringing to trial those who may be justly accused and shielding the innocent from unfounded accusation and prosecution. We do not agree. The rule would neither preserve nor enhance the traditional function of the institution that the Fifth Amendment demands. To the contrary, requiring the prosecutor to present exculpatory as well as inculpatory evidence would alter the grand jury's historical role, transforming it from an accusatory to an adjudicatory body. It is axiomatic that the grand jury sits not to determine guilt or innocence, but to assess whether there is adequate basis for bringing a criminal charge. As a consequence, neither in this country nor in England has the suspect under investigation by the grand jury ever been thought to have a right to testify or to have exculpatory evidence presented. Imposing upon the prosecutor a legal obligation to present exculpatory evidence in his possession would be incompatible with this system. If a balanced assessment of the entire matter is the objective, surely the first thing to be done, rather than requiring the prosecutor to say what he knows in defense of the target of the investigation, is to entitle the target to tender his own defense. To require the former while denying, as we do, the latter would be quite absurd. It would also be quite pointless, since it would merely invite the target to circumnavigate the system by delivering his exculpatory evidence to the prosecutor, whereupon it would have to be passed on to the grand jury, unless the prosecutor is willing to take the chance that a court will not deem the evidence important enough to qualify for mandatory disclosure. Respondent acknowledges, as he must, that the common law of the grand jury is not violated if the grand jury itself chooses to hear no more evidence than which suffices to convince it an indictment is proper. Respondent insists, however, that courts must require the modern prosecutor to alert the grand jury to the nature and extent of the available exculpatory evidence, because otherwise the grand jury merely functions as an arm of the prosecution. We reject the attempt to convert a non-existent duty of the grand jury itself into an obligation of the prosecutor. In Costello v. United States, we held that it would run counter to the whole history of the grand jury institution to permit an indictment to be challenged on the ground that there was inadequate or incompetent evidence before the grand jury. It would make little sense, we think, to abstain from reviewing the evidentiary support for a grand jury judgment while scrutinizing the sufficiency of the prosecutor's presentation. A complaint about the quality or adequacy of the evidence can always be recast as a complaint that the prosecutor's presentation was incomplete or misleading. Our words in Costello bear repeating. Review of facially valid indictments on such grounds would run counter to the whole history of the grand jury institution, and neither justice nor the concept of fair trial requires it. Respondent argues that a rule requiring the prosecutor to disclose exculpatory evidence to the grand jury would, by removing from the docket unjustified prosecutions, save valuable judicial time. That depends, we suppose, upon what the ratio would turn out to be between unjustified prosecutions eliminated and grand jury indictments challenged. For the latter, as well as the former, consume valuable judicial time. We need not pursue the matter. If there is an advantage to the proposal, Congress is free to prescribe it. For the reasons set forth above, however, we conclude that courts have no authority to prescribe such a duty pursuant to their inherent supervisory authority over their own proceedings.